Fifth District Court of Appeals in Dallas, Texas is now in session. Justice Myers presiding.
Good afternoon. I'm Lana Myers, and my colleagues sitting on today for today's oral argument with me are Justice Bill Whitehill and Justice Bill Peterson. The attorneys, if you could please introduce yourself. The appellant's attorney, Ms. Blacknall.
Rita Blacknall for the appellant.
And for the state?
Jennifer Bolito for the state of Texas.
All right. Thank you all for participating in this oral argument. I'll call the case. It is our case number 0519000178 CR. Tradareon Jamel Choice versus the state of Texas. And we set this case for oral argument in our order stated that Ms. Blacknall, at the time of our order, had 24 criminal appeals currently pending before the court, that she had filed a brief on the merits in one case, had not yet filed a brief in 4 appeals, and we indicated in our order that we would focus on Choice v. State in this oral argument, but we also reserve the right to talk about other cases in which Ms. Blacknall has filed Anders briefs as listed in that order. So I have reviewed the entire record in the Choice matter, the Choice case, and I'd like to start, Ms. Blacknall, with you. You've got 20 minutes, and so I would like for you to just walk us through why you think that an Anders brief was appropriate in this case based on, specifics in the record.
Let me just say, I just have a brief statement, probably will take me about a couple of minutes. I'm attorney Sharita Blacknall. I was appointed to represent Mr. Choice on appeal. I reviewed the record and I determined that, in my professional opinion, the record reflected no reversible error. I did not request oral argument, and I have nothing to add, and do not believe that the decisional process will be significantly aided by my oral argument. When I first received notice that I needed to do an oral argument in this case, I sought out the advice of several judges, appellate prosecutors, and appellate defense attorneys. Every person that I talked to said that they could not give me any advice because they have never heard of anyone being asked to give oral argument after submitting an Anders brief. I went online to research to see if I could get any guidance and did not find any. This caused me to reflect on the entire situation, and I had many thoughts about what I was being asked to do and why. I concluded my reflection with the decision to remove myself from the appeals appointment list and ask that all my pending appeals be assigned to other counsel. All of the pending appeals I had have since been assigned to new counsel. The format that I used in the Choice case is the same one that I have used since I have been on the appellate appointment list. Many of those appeals that I have previously submitted Anders briefs for, I received notices from the court that the court agreed with me that they should be Anders briefs. So I don't have anything to add with respect to this appeal, except that I reviewed the record. I went through the same format that I always go through. I didn't see any reversible error or any places where the defendant's rights have been substantially violated in any way. So I don't think that I have anything to add that would aid you guys in the decisional process.
Okay.
Ms. Blacknall said that, hold on. Can you hear me?
I can.
Yes.
Yeah, okay, sorry. Ms. Blacknell, you said that you didn't identify any reversible error. Is it your view that an Anders brief is that unless appellate criminal defense counsel can identify error that will be harmful and will necessarily result in a reversal of the conviction, there is no need to brief or address any lesser type of error?
Well, I wouldn't necessarily say that that's my position. I would say that I addressed what I thought needed to be addressed in the Anders brief that I submitted.
Okay, because
I was not aware that there was any particular format or any particular, requirements that every issue needed to be addressed or,
do you, I just assume that any orders or opinions that are issued by this court in any cases to which you are in which you are representing one of the parties, that you read every word of those orders and opinions. Is that a fair assumption?
Did I read every order? Yes.
Okay, because like in Gerald Jefferson Munoz Montano, which is on our list in our order, on March 18th, you received an order. There was a memorandum opinion that was the panel was Chief Justice Burns, Justice Lana Myers, and Justice Carlisle that addressed your Anders brief. May we safely assume that you read that order?
I'm going to be honest with you. I probably read it, but as I'm sitting here now, do I recall everything that was in that order? I can't say that I recall everything that was in that order. These were orders and briefs that were done probably a year ago, some of them. So I can't say sitting here now that I recall everything that was in there. Did I read it? I'm sure that I did.
Has anything in the last, there was also an opinion issued on January 28th of this year, Brandy Nicole Crow versus State of Texas, that was on the panel included Justices Osborne, Partita Kipnis, and myself, wherein there was a published opinion about your attempt to write an Anders brief. Are you at all familiar with that published opinion that came out at the end of January?
Honestly, I read it at the time. Sitting here now, I don't recall everything that was in that opinion.
When did you decide to get off the appellate wheel?
As I stated earlier, when I received notice of what I was being asked to do as far as oral argument for this choice case, I sought the advice of several judges as well as several appellate attorneys on both the prosecution side and the defense side. And after receiving no advice from anyone, and after reading all the opinions that you speak of, and as well as the notice of me being asked to come here today, well, actually, this is a reset from a previous date from a couple of months ago. I believe it was the first time was on March the 26th. I decided that that at that time, to get off of the list, I sent the Dallas County, I guess she's called the court manager, a email telling her to remove me from the list. And then I proceeded to contact all of the courts that I had pending cases in that I had not done briefs for yet, and asked them to reassign those cases to other attorneys, and each court assigned those cases to other attorneys. So it's been probably a couple of months now that I have been off of the list. And I'm not on any list anywhere else.
Well, what do you mean you're not on the list anywhere else?
I'm not on any other appellate wheels anywhere else.
You're
in
talking
any
about
other counties.
other counties? Okay.
That's correct.
Okay.
And in fact, I actually removed myself from all court appointment lists from every county that I was on the list for. not only appeals, but other cases as well.
Well, having received our order setting this for oral argument in this Choice v. State case, did you go back and look at the record and reconsider whether there were any arguable points of error that could be raised?
I did go back and review the record. However, my opinion still didn't change.
Okay. I'm not sure what happened to Justice Peterson. Do you recall from the record that counsel for the defendant, Ms. Moore, Valerie Moore, made an objection to an extraneous aggravated robbery coming in?
Do you mean the objection that she made that one of the officers talked about a shooting that had occurred prior to the incident? That,
Correct.
Yes, I think I recall that.
Correct.
She did make an objection to that. The judge addressed it. The officer never mentioned that we're talking about the same incident in the record, the officer never mentioned the fact that Choice was related to that incident in any way. He never testified that. He just said, I received a call when I was coming from a shooting, if I remember correctly.
Okay. There was also an objection made. This was a jury trial, at least on guilt innocence. The trial court assessed a life sentence, but it was a several-day jury trial. But at the end of the jury trial, Ms. Moore also made an objection to not having received some information regarding, well, I can't think of his name. I think his last name was Valdez.
It was.
And the court addressed that, allowed the prosecutor to put on some evidence concerning that, but still the objection was made and it was overruled. Do you recall that?
Yes.
All right. And is that not something that you would, that you felt like you needed to even bring up in an Anders brief and then explain why it was Mr. Choice was not harmed?
At the time that I wrote the brief, I didn't feel that I needed to. As I stated before, I just used the same format that I've always used, and the court on many occasions has agreed with me that an Anders was proper in those prior cases. So I just used the same format that I've always used. But yes, I do recall what you're talking about. Mr. Valdez was called as a witness by Miss Moore, if I recall correctly, and he pled the fifth. I believe is what happened.
Okay. Well, let me just say, Ms. Blacknall, that, you know, I've spent a considerable amount of time going through in several of these cases where you filed Anders briefs, including Choice, including the next argument that we're going to hear, Isaac Jimenez v. State. And I think, at least in my view, I have a serious concern about the fact in most of these cases, you did not file a motion to withdraw at the time that you filed the Anders brief, and then the court has to send you an order telling you to file your motion to withdraw. And in many instances, we didn't hear from you. And so then we had to follow up with another order. And then eventually you finally filed a motion to withdraw. Is there some reason why you failed to file a motion to withdraw in most of these Anders cases when you were supposed to?
Your Honor, I don't recall each instance that you're referring to or what the reason was. However, I do apologize for any inconvenience that it caused to the court for me not filing those motions to withdraw. I am a solo practitioner. I have at the time, I had a very busy schedule. So I can't really say with specificity what the reason was for each of the incidents that you're talking about. However, I did my best to try to remedy that situation by filing the motions to withdraw.
Well, I have a few of the cases. I hope you understand. I've been a judge for 25 years, and at some point, when the judge issues an order, the judge expects that it will be followed. And at some point, when order after order it's being what appears to be ignored, then that's a problem. Do you understand that?
I understand, Your Honor, that it may appear that I was ignoring your orders. However, I would let the court know that it was never my intention to ignore any order from the court. I have the utmost respect for the court and any order that the court issues. However, as I stated, at the time I had a lot of cases coming in, a lot of emails coming in. Sometimes some of the emails that I would get from the court would be filtered out. Sometimes they would go into bulk mail and I wouldn't see them. Sometimes, there were just various things that happened, but I will let the court know that it was never my intention to ignore any order from the court.
Well, in some instances, you actually sent the letter your letter letting them know that you filed this Anders brief and they have a right to file a pro se response to the wrong client.
I think that happened on one occasion that I'm aware of, and that was because the defendant's name was misspelled in the TDC system. And the particular facility sent me a letter back saying, hey, you sent this to the wrong inmate. When they sent me back the letter saying that his name was spelled differently, I resent the items to the correct facility. And then I assumed that the person got it because it never came back to me, and I never received any indication from the defendant again that he didn't get it. But his name, if we're talking about Isaac Jimenez, his name was spelled incorrectly in the TDC system. So that was good. So I did mail it to him, and they, like I said, the mailroom sent me back a letter saying, hey, this is not the correct Isaac Jimenez.
Well, and I looked at that record too, and that's our next oral argument. But since we're talking about it, actually, the spelling of Mr. Jimenez's name came up during arraignment, and the court actually struck the additional S in his name. That never got corrected on the trial court judgment, and it never got noticed by you either when you reviewed the record. isn't the only time it happened. Mr. Justice Peterson mentioned the Montano case. And in that case, authored by Justice Carlisle on our court, he mentions that though the attorney listed the correct unit name for Mr. Montano in the letter informing him of the Anders brief, the address the attorney listed is for a place on the Bolivar Peninsula, the sliver of land separating Galveston Bay from the Gulf of Mexico, not a place the Texas Department of Criminal Justice houses any prisoners. And the TDCJ identification number the attorney listed corresponds to another man.
I understand, Your Honor. It was an oversight on my part. As I stated, I can't do anything about what has happened in the past. I have done what I feel was the correct thing to do to remedy this situation. So there's really nothing that I can do sitting here now at this point about that, but I've done what I feel was necessary for me to remedy the situation.
Well, and in another case, Xavier Damon Collier, that's our case number 0519013119 CR. Mr. Collier, in your letter to Mr. Collier, and he brought this to our attention because, you know, we get letters from these appellants who are in prison, and many of them serving substantial penitentiary time. And Mr. Collier wrote us a letter informing us that, well, you know, you gave us a copy of the letter that you sent, you know, which got his correct name, but wrong TDC number, and also addressed the letter to Mr. Sampson, a different client. That's a different case we have in our court. And also indicating that he had been found in your letter, indicating that the trial court had found him guilty and sentenced him to 2 years TDCJ ID, when in fact he got an 8-year sentence in the penitentiary. So I guess that was Mr. Sampson's case you were talking about when you were writing Mr. Collier. And go ahead, Justice Peterson.
Well, we all feel very strongly that the different players in this equation, Ms. Bolito representing the state of Texas, you representing the people who have been accused of crimes, and the court, our job is to make sure there's integrity in the proceedings in the trial courts that we supervise. And that's what Anders briefs are about. They're not about rapidly just, resolving a case so a lawyer can move on or anything like that. And we're just very concerned with this. And I appreciate that you have gotten off the wheel and that you have transferred all your cases to other lawyers. But it would be impossible for me to overstate how disturbed I am by what I've seen in this record. And I think it's important for you to understand that.
I think that I do understand, Your Honor, which is the reason why I voluntarily removed myself from all appointment lists.
I mean, put yourself in our situation.
About 2 months ago.
Put yourself in our situation. What should we do? What advice would you give in resolving?
I can't answer that for you, Your Honor. I guess you guys did. I mean, you did what you thought that you needed to do. And so, I'm here. As I stated there, I have addressed the issue in the best way that I know how to address it. I can't go back. So I addressed it 2 months ago, the best way that I knew how to address it.
Are these deficiencies correctable in the future?
Yes. Although I don't think that there will be any I mean, they are correctable in the future, but there is no, future for me as far as I can see it at this point, as far as the appellate rule is concerned.
Ms. Blacknall, have you actually physically been to the Fifth Court of Appeals?
Yes, I have been there to check out records.
Well, do you know the address for the Fifth Court of Appeals?
It's 600 Commerce Street.
Then why would you, in your letters to your clients, informing them that you had filed an answers brief and that they could file a pro se response, show that our address is the Frank Crowley Courts building?
It was a typo, Your Honor. It was a typo.
It just, like I say, I just, looked at many of these cases that you filed an Anders brief, and one of them, and my radar went up when I started looking at really just how many, just the correspondence between the court and you, trying to get you to do, file your motion to withdraw, give us verification that you've sent, this to your client, with no response from you, just order after order. My radar went up every time I saw a case from you. And so, for example, the Joseph Glenn Robertson v. State case, that was an opinion authored by Justice Shank, and I was on the panel in that case. And, it's a minor point, but it's a detail. And I'm detail oriented. I always have been. But do you know the difference between judicial notice, taking judicial notice, versus admitting a document into evidence?
Yes.
Well, for example, the lack of attention to detail was evident to me in your Anders brief in the Robinson case, because you certify that this is what you found in the record, which makes me really question that, because, or is it just boilerplate? Because this was a plea of guilty to the court. But in that case, you certified that the court admitted the judicial confession into evidence. And then when I looked at the record, no, that's not what happened at all. What happened was the prosecutor asked the court to take judicial notice of the judicial confession, and the court did. Is there a difference to you there?
I would say, Your Honor, that there is technically, I guess, a difference. How, maybe my words weren't precise, but when I say admitted, I guess I'm saying basically that in that instance, that admitting it and taking judicial notice, I was using them interchangeably, I guess is the best way to say that.
Do you understand how when I see that, if I were an attorney writing a brief, and the record said that, what it said, that the court took judicial notice of the judicial confession, I don't think that I would right that the judicial confession was admitted into evidence. Does that make sense to you?
I hear what you're saying, Your Honor. I guess in my opinion, when I was writing that, they had the same effect. So, but yes, I do hear what you're saying, Your Honor. Whether it was admitted, whether I use the word admitted or took judicial notice, in my mind, I was using them interchangeably because the effect was the same.
Do you understand when you do, even though, you know, that's a minor thing, but you understand when you do that, it makes me question, well, what else has she not noticed? You know, did she read this, the whole record?
I did read it.
Or are you just getting it, you know, what you need from the table of contents, the list of witnesses, the opening and closing statements by the attorneys? Just
No,
the
Your Honor,
gist?
no, Your Honor, that's not correct. I did in fact read the record. As I stated, I mean, to me, judicial notice, admitted, it was the same effect. I used the words interchangeably. I wasn't as precise in my words as you would be.
Do you think we're being unfair to you?
I really don't have an opinion about it one way or the other. I don't think that my opinion about it really matters. As I stated, I have done, you know, what I can at this point. I do, you know, as I stated earlier, I talked with several judges, several appellate attorneys on the prosecutor side and the defense side to get advice from them about how to prepare for this oral argument. And every single person I talked to said that they had never heard of anyone being asked to do what I have been asked to do, so they couldn't give me any advice. I wouldn't say that you guys are being unfair. I'm saying, I would just say that you have asked me to be here, and I have done what I can, you know, to be here to answer the questions that you guys are asking me. So I wouldn't say that you're being unfair. I'm not really sure why you asked me that question as to whether or not I thought you guys were being unfair, because I never given any opinion to anyone one way or the other. I just took the action after reflecting and reviewing the situation on what I was being asked to do and why, and I took the action that I thought was best.
Do you think you discharge your obligations to your clients in these cases?
I don't, because I still stand by the position that there was no reversible error there. And in some of those cases, the court, in fact, agreed with me that the Anders brief was the proper thing to file in those instances. So I wouldn't say that. I would say that were there some typos and some technical errors there may have been. I don't recall all of these cases. Like I said, some of these cases are probably a year, if not more, older than that. But that being said, there is nothing that I can do to go backwards. I can't go back. So I took the action that I thought was proper.
Well, I think it's important for us to establish that whether or not reversible error is the only type of error that should be argued. I mean, it sounds like you're only going to swing at the pitch if you think you can hit a home run. And that's inconsistent with my personal understanding of what an appellate counsel's obligation is. And I'm trying to understand how you came to the belief that you have repeatedly espoused, both in your briefs and today, that you didn't think any error was reversible in your judgment, and therefore you should file an Anders brief. But in that Anders brief, you don't help us have confidence in the proceedings below, because you don't identify. You note that there were evidentiary objections repeatedly in this brief, in these different briefs, but you don't identify those objections. You don't give me a record cite for them. You don't cite any cases about any evidentiary objections. You don't address harm, as far as I can see, in any of these briefs at all. which kind of cuts contrary to your suggestion that there's no, I would think if you say there's no reversible error, you would have to identify some error, and then you could make the argument it's harmless. And I just wanted to explore how you came to understand your obligation to be that only reversible error merits address.
Well, it was my understanding that there was no set format for doing an Anders brief, and that I was supposed to be looking for what I thought was reversible error, and that I didn't know that I had to address a certain number of things, or
How did you come to?
I addressed the things.
Go ahead.
I addressed the things that I've always addressed, and that the court has previously agreed with me on. I don't think that it serves anyone to just make up issues and write about things that the court is not going to reverse, and then the client doesn't have an opportunity to write a pro se brief, or for the client to be able to come forward to put his own arguments forward if he doesn't agree with my assessment that it wasn't reversible. I don't think that it serves them for me to just like, okay, well, I'm afraid to write an Anders, so I'm just gonna make up issues that I know that the court is not going to reverse. I reviewed the record in each of those cases. I came to the conclusion that an Anders brief was proper, and in most instances, so far, the court agreed with me in most of those instances that an Anders brief was the proper thing to do. Now, I understand that we're here now in this instance, and there are several cases that the court has questioned. As I stated, I can't go back and do anything about those cases. So I did what I thought was the proper thing to do.
Well, for the cases where a no motion to withdraw has been granted, you could file an amended Anders brief, or if you, on further review, decided there was some merit to some argument about error, that's one thing you could do, isn't it?
If the court would like for me to do that, I can. As I stated, I use the same format that I've always used. And if the court wanted me to do that, I guess that is something that could be done. At the time, as I stated, I reviewed the record, and it was my opinion that there was no reversible error. Now, did I write about every single objection that I saw? I didn't write about every single objection that I saw and say, hey, on page so and so.
It's a little different than that. You didn't identify any evidentiary objections in really any of these briefs that we've cited. Do you believe that evidentiary objections are never reversible?
No, that's not my position at all. My position is that when I reviewed the record, the objections that I saw, that whether they were overruled or sustained, I didn't feel that they merited reversible error. I mean, that was what my position was. Is that I have a list of, like, in this volume, this was objected to, blah blah blah, whatever. But I didn't feel that it was reversible. And so, to me, it's frivolous to write about things that you don't. I mean, that are not going to be reversible. I mean, I don't know how else to answer that question for you, except to say that it's not that I didn't see the objections there. Of course, I saw the objections. Yes, I saw the objections, but I didn't feel that it was necessary for me to say, in this volume there were 30 objections, and none of them, this is what they were, and none of them were reversible. I didn't feel that it was necessary, because I had done it the way that I had always done it, and the court, in most of those instances, agreed with me that the Anders was the proper thing to do. So I just wrote it the way that I always did. Not that I didn't see the objection. Of course, I saw that the objection was there, but I mean, I didn't see it as a reversible error, and I had did it the way that I always did.
Thank you.
Ms. Blacknall, we've mentioned the Crow opinion authored by Justice Osborne. But I mean, I can't recall, you may have answered this question, but did you read Justice Osborne's opinion in that case? It's
I'm sure that I did,
Kobe
Your Honor.
State 2020 Westlaw 428151.
I'm sure that I did, probably about 3 months ago.
Well, it's a good recitation of the law concerning Andrew's briefs and addresses what we've been talking about, what Justice Peterson's been talking about, and states in that case, and cites Hy-Vee State 573 Southwest 2nd 807 811 Texas Court of Criminal Appeals 1978 case, holding that an Andrew's brief filed in a contested case must describe any objections raised and ruled on during trial and discuss either why the trial court's ruling was correct or why the appellant was not harmed by the ruling of the trial court. Indeed, the failure of appellant's appointed attorney to discuss this issue in the brief filed shows that she failed to make a thorough and professional evaluation of the record. See Anders.
So what is your question, Judge? I'm sorry.
Well, I mean, do you think, I mean, I've just read to you what the Crow opinion says, citing Texas Court of Criminal Appeals case. But as Justice Peterson said, I mean, you haven't addressed any of these evidentiary issues or objections made in the trial court's ruling, whether it was right or, whether it was correct in any of these Anders briefs that I've looked at.
And Your Honor, my response would be the same, that I use the same exact format that I always use. And in many of those instances, the court agreed with me that the Anders brief was the proper thing to do. I don't believe that I've written any Anders briefs or turned in any briefs, maybe. I'm not sure since that Crow opinion. I don't recall if I have or if I haven't, but I can only say to you that I did the same thing that I had done in the past, and the court agreed with me in most of those instances. They never said to me, hey, you were supposed to address every single objection that was made. I've seen several samples from other appellate attorneys who have practiced in front of this court before, and most of them the samples that I looked at don't address every single objection. And so looking at those samples from those appellate attorneys, many of which practice in front of the court a lot more than I do, they didn't object to every single objection that was made. And so, as I stated before, I was not aware that that was what I was supposed to be doing, in light of the fact that I have used the same format since I've been on the appellate list. I've used this exact same format, and the court has agreed with me on most of those occasions that the Anders brief was the proper thing to file. So, I heard what you read. I understand what you're saying. If I ever have to do it again in the future, if the court is telling me that you want every single objection to be noted, then that's what I will do. Well,
and I'm not telling you every single objection needs to be noted, but I am saying that, if it is, an objection that goes to the heart of the defendant's case, wipes out you know, the, you know, it just depends. It depends on the circumstances. But if it, you know, has a substantial effect on the case, then I think it should at least be addressed and tell us why the court
For
was
example-
correct.
For example, in this case, the choice case, the one for which you were specifically been called for oral argument today, was there a proposed instruction to be added to the charge? Did the defense attorney below do that?
Yes, she did.
Why did I not know that when I read your brief?
I don't know, Your Honor. Like I said, I mean, I can only repeat to you the same thing that I have, that I use the same format that I've always used.
Well,
I
and
use the same format.
does that mean that
So it didn't seem like, I mean, for me to say, well, the defense attorney objected to this, and here's why she was wrong, and it wasn't reversible error. No, I didn't do that.
I mean, when you refer to previous instances where you filed Andrews briefs that were accepted by this court, it sounds as though you're suggesting, well, that was a signal to you that you were doing what you were supposed to do. And I can understand why you would draw that conclusion potentially. But the concern that I have is there real integrity that I can have faith in those previous cases? It's likely that in those previous cases, the court, as it is required to do under the law, and as you're required to do under the law, believes that you thoroughly understand and appreciate every representation you make in every document that you file under your signature with this court. And perhaps we should have concern about the integrity of those previous cases that got through somehow or another. Do you have any comment to that?
Your Honor, I can't comment on. All I can tell you is that I reviewed the record. I can't stop you guys from having any question about the integrity. I mean, whoever the judges were that reviewed those submissions at the time, they felt that the Andrews brief was the appropriate thing to do. I felt that it was the appropriate thing to do when I filed it. And so all I can tell you is that they felt that those were the proper thing to do. I can assure you that I reviewed the record. I guess if that's what the question is that you guys have is, did I in fact review the record? Yes, I did in fact review the record. Did I address every single objection or whatever in the briefs? No, I didn't address every single objection. If I didn't feel like it was reversible, I addressed the same things that I always address. I review the record, I write down my notes, I look, is this reversible? Can I make some kind of argument here? Is it harmless? Is it not harmless? You're never going to go through an entire trial without having some error, but the question is, was it harmless or not? So I make those notes or whatever, and then I turn my brief in the exact same format that I have always turned it in. I can't speak to what the judges who said that in the past that the format that I use in the Andrews brief was okay. I can't speak to that. All I can do is take the order that they gave me saying, that they agreed that it should be an Andrews brief at face value. They sent me an order saying that you filed this Andrews brief. We agreed with you. And I mean, I don't question it. If they say we agree with you, I don't have any reason to question, what they're saying. I don't, and I don't want to just like make up things to write about or, that's never my intention is to like just make up things or whatever. But as far as the integrity of what I've done, I don't have any question about my own integrity. If I say I reviewed the record, I reviewed it. So I don't have it, and I can't stop you from questioning it. But if I say that I reviewed the record, then I reviewed it. I don't have any reason to lie or make up the fact that I reviewed the record, because I in fact reviewed it. I just didn't see any reversible error. And in most of those instances, the court agreed with me.
Okay. Thank you, Ms. Blacknall. Any other questions of Ms. Blacknall? All right.
Has there ever been an instance where you submitted an Anders brief and the court disagreed and said that there should not have been an Anders brief?
I believe recently, since Judge Myers or whoever the judge was that sent out the order about me being here today.
Okay.
I think there may have been, I want to say the Crow, maybe the Crow, I can't remember exactly, but maybe it was the Crow case that Judge Myers was talking about. I think the court asked for another lawyer to be appointed on that case. I can't recall, but I think that happened in that case.
Montano.
And yeah, in that case, those are the only two that I'm aware of. And I don't know that those lawyers found any reversible error either. So I at that point, it was out of my hands. So I didn't keep up with it after that.
All right. Thank you. Ms. Bolito,
Yes, Judge,
you have a few minutes.
I do.
Do you have anything to say?
Judge, I would just like to say that when the order came out for this court and then also for the Jimenez case, that Ms. Blacknall came and sat down with me and we discussed the order coming from the court. And I encouraged her to go back and look at the record and see if she found any error. Again, because I believed that if she did find error or could make an argument that there was error in the trial transcript, that I believe that this court would accept as a supplemental brief, and that we would not object to that. And then I also encouraged her to take herself off the appellate wheel and also to withdraw from the cases that she had pending that she had not filed anything for. Because in my practice, when I got busy and got overwhelmed, there were times that I would take myself off the wheel until I could get my practice back under control. So I thought that was good advice to her. I have reviewed the record, and of course, as a state, we're not conceding that there was any error that should reverse these cases. But I did see the 2 points that you pointed out, Justice Myers, as to in specific with Mr. Choice's cases. And additionally, I saw that that there was also some victim impact testimony that was brought out by the state early. And then also there was a question that the detective was asked that I thought, might need to be explored. I don't know, I didn't go through all the research on it. And then also I had marked in my notes also the jury charge question that Justice Peterson brought up as well. So, I think that Ms. Blacknall is a good attorney. I've seen her in the trial court representing her clients. And so I am disappointed in what has happened in these cases. And we're willing to do whatever we need to do with the state to make sure that the defense is heard, that the defendant has his rights put forth to this court as he should be, by appointing counsel, because he can't afford it to hire his own counsel. So I mean, I'm sorry, our desire from the district attorney's office is that justice is done, and justice is a full and fair hearing of all the issues by the trial level or the appellate level or the writ level. And so whatever we need to do to make sure that that's done is what we will do.
Do you agree with Ms. Blacknall's view of her obligations in an Anders situation, that only reversible error needs to be addressed in a direct merits appeal?
No, not necessarily, because, and we kind of discussed this when I discussed it with her when she came to see me is, you know, I believe that the determination as to whether or not something is harmful, you know, is, you know, I can make my arguments that as if I was appellate counsel, that it is harmful. The state would argue back that it's not harmful, and it's ultimately the judge's decision, looking at the record in its totality, whether or not it was harmful to the defendant or not. So I personally, as an appellate lawyer, when I represented clients and defendants, I wasn't looking just for reversible error. I was looking for errors that might have, you know, that I could argue harmed my client. And so I didn't look at it that way. I thought my obligation was to look at everything that I could, research it, and quite frankly, even if all the law was against me, I still would argue that in my client's particular situation, it should be different because it did harm my client in that situation. So we were talking about it, you know, in our office today, that, you know, Crawford lost his case, you know, Crawford versus Washington, however many times in the levels, you know, but that lawyer kept on pushing and pushing and pushing, and it totally reversed the whole about, you know, admission, I mean, an excited utterance situation. It totally changed the law when it got to the Supreme Court. And that's what that lawyer did, was push and push and push until the law was changed. And that's what you have to do in situations, some situations.
Any questions for Ms. Bolito?
Nope.
All right. Thank you, Ms. Bolito, Ms. Blacknall. We wanted to set this for oral argument because we had serious concerns about the number of Andrews briefs filed, the ignoring the court's orders, findings, you know, objections that were never addressed at all in the trial court in these Andrews briefs, and believe that, you know, it's, you know, we're, as appellate judges, you know, we want to make sure that justice is done and that both sides get a fair hearing, you know, in the appellate court. And so, anything else?
Nope.
Okay, well, I think we have another argument at 2 o'clock in Isaac Jimenez versus State. So we'll see you in a minute.
Thank you, Judge.